Section 13, we're on the second half, and we don't have that many cases tonight, so we can finish them up and get the heck out of here. No, but we will. We will be done. We will be done earlier. There's only 2 cases, but I also want to say this about the complaint, because people have had questions about it, and I think we were probably offline by the time Stephen and I had our discussion the other night. I think legit. I would want you to file a federal court complaint, and I do think that you can stretch copyright violations in order to have a federal question in there. And you should be able to file that in federal court under those circumstances. So I know there's been some confusion looking at it. How do you get diversity? How do you do this? Which I did want you to think about those issues. But I think you do have at least sufficient basis to probably allege federal jurisdiction under copyright. And I won't move to dismiss you under Rule 12, so we'll allow your complaint to stand, but you got to get your complaints done. And it's not you guys. It's not really you guys. I'm saying this for the people online. I've gotten some questions as well over time. So,
can you give us a waiver from subject matter jurisdiction?
Can you what?
Can you waive?
No, you know you can't.
I know. That's what I'm saying. I'm not.
But I'm the judge here. I'm taking. I'm the judge and the other side.
Okay, if you're the defendant, I'm.
Oh no, no. There is a legitimate question whether you're squeezing it into federal court where it doesn't belong. I mean, frankly, in the real world, it's not. Well, they've stolen copyright material. It's a question of them whether that falls in under the Copyright Act. And as someone pointed out, you do not have complete diversity either. So either we leave potentially an essential defendant off and get dismissed under Rule 19, or we manufacture a basis to stay there. And I think the best it gets is the potential copyright violation. But without doing some real legal research, I don't know whether theft of copyright material is actually copyright violations. I would think it would be. It's just another form of theft, but I'm going to make your job a little simpler. Because otherwise then you'll be saying, well, which county do we go and all the rest of it. And the idea was just for you to put pen to paper and start to think about what complaints need to look like as you start to think about becoming a lawyer and filing them and the like. So,
just real quick on the fact section, there's really no dates or anything, so we just kind of make it as generic.
Yeah.
Okay. I mean,
yeah, you can fill in reasonable dates. I wouldn't expect the statute of limitations has run just yet. We only started in January here, so. You don't need to make it more complicated than it is. Okay? Just get it done, because you want to be moving on, getting ready for your final as well. So we're still looking at interference with real property rights, and now we're left with Pate versus City of Martin, which is another case I've always actually enjoyed, because we have again, in a lot of these situations, you actually have to measure, is it temporary or permanent? And then, well, are there means of, and temporary is fixable, permanent is not going to be fixable, potentially. So we might have to either award permanent damages or issue an injunction, and it's going to shut something down. And a lot of these cases we really are thinking about and trying to figure out what the social utility of the nuisance might well be, whether it's the cement plant or the airport, or in this case it's the sewage lagoons and the like. And obviously, if you live near a sewage treatment plant, it's problematic. If you live too close to a small airport that's growing, it's problematic. The incinerators are a problem. Dumps are a problem. I mean, you name it. Well, let me ask you that. Are there items of this sort in your towns that you've come across that you think about? You're nodding your head like what?
I live like maybe a block or two away from the Nashua Airport, so there are planes all the time.
From Nashua has an airport?
It's really tiny. They're like little commercial, but they're.
But they are commercial.
Yes, they are. They're tiny. They're not those big like 7.
You mean like single engine aircraft, like
what?
Those Cessnas, single engines or commercial?
I wouldn't know.
Oh, okay.
And I know I can hear them. They're loud. They fly really low, so I see them all the time.
We had a trash incinerator called Merck in Biddeford, and it was releasing ash.
Mercury, yeah.
Ash, and it was getting all over cars and houses and stuff. And they eventually got so much heat from it that they ended up tearing the whole building down. They sold it and tore it down. It's now a parking lot.
What else you got? None of you have anything else? Because on my way home alone, I go past the sewage treatment plant. I go, and this is all North Andover. I go past the airport, which the airport, our airport's not bad, but if it turns into Manchester, we're going to have problems because they fly real low. I mean, really low, even as they come over 125. But there's not as that much of it. And then just the other side of the house, we have an incinerator that does an awful lot of business, and there is some suggestion about whether that contributes to asthma and things like that. And obviously, a lot of times these things become problematic as the neighborhood grows and the like, or that the activity picks up. And people are willing to pay for you to litigate these issues because they don't want to have these problems. By the way, I have the article at home. I left it from when I was reading it the other day. There is another surrogacy case that just came out. It just started. This couple are suing the, it's not the surrogate, they're suing the sperm donor agency because they were led to believe that the sperm donor was, 190 IQ with advanced degrees and I don't know what else. I'm just puffing it up probably beyond what it was. And as it turns out, he's relatively low IQ schizophrenic. At least.
Wow.
And it's not very funny actually, right? The child's now 7. I don't know whether there are further issues already developing with the child, but what it seems to be the fight is about is the agency is saying, well, we didn't describe him that way, which leads me to believe, well, he described himself as much better than he is, which those of you women who know men, that tends to be what we do, isn't it? And they're upset because they didn't get their prized genetic material as it turns out. Because I guess he really is what they're saying he is. The question is, did we oversell him? Did he oversell us? And therefore, I don't know what, I'm going to get you the article because it's an interesting article. And again, it raises some serious issues about that type of litigation. I mean, if there aren't health issues, are you really just suing because you didn't get the cream of the crop? I mean, is that was that important, the super high IQ and all the rest of it? Because life just doesn't work out that way as a general matter.
It'd be interesting to see what kind of agreement or contract that they signed to see whether or not they said they do background checks, to see whether or not.
Well, but would you?
Well,
You think you're required to, though, too?
Required to. But
Required to do background check on a sperm donor? How much do you get to sell it? How much does the person gets next? My recollection when we read the articles, it's like $15 to $25, and I don't think the cost to pass it to the next level is a big markup. I'm supposed to now do a thorough background check. Because what's the chance, by the way, if you think about it from a business standpoint, I mean, a lot of times it's students looking to pick up some quick beer money and the like, right? Well, I think that would be the market as a general. I do think that's the market. They're usually near med schools and they're near colleges and universities.
secured system. Genius.
But
Sure.
do you really? Would you impose a requirement that they really thoroughly investigate the donor, other than I think it said they tested him for AIDS and something else?
Well, I mean, I think it's simple. Since people care so much about it, it's the person who's getting the donation, I suppose, if you want to call it that way. If they're wanting to fund it, Why not?
Oh, fund a more thorough,
Yeah, like if I.
like you want the super duper, then we'll give you the super duper
Right.
investigation
Yeah,
as well.
and I wouldn't get involved in this anyway, but if I did, I would say it would be worth $300 to check out whether I'm getting a schizophrenic donor.
Well, see, and that's what what about the notion of you're getting, the potential genetic defects that are now passed along, and they're not, at least it appeared, and if you think about it, thinking logically about it, they can't test for everything. I mean, and they're not going to, and so where is the liability there when it turns out to be not just less than represented? Well, how much less must it be than represented, and what are the damages? We go back to that issue that we saw in those cases. So I'll get you the little article. It's a relatively short article, but it raised a lot of the same issues we talked about, but even more, it made me think about, well, what is their obligation to actually verify what your claims are? And you would think there probably should be some, I guess. Right? If you're saying this is 190 IQ, well, what, based on what you say? I mean, is that's no verification then? So you get some blowhard and you he used to be an astronaut, was one of the third people on the moon and all the rest, and you say,
Selling shots for $25 a pop. Come on, let's think this through a little bit. You know what I mean? Like if you're gonna be that serious about it, you've got to do your due diligence and you got to pay for it, right? I mean,
but they're not necessarily, if I'm the purchaser, they're not necessarily going to give me they don't even always release the names. That's part of it.
oh, okay, I see.
Right? So you know what I mean? So I'm not going to be able to do it, but should you pay the agency to do it then? Or should the agency require some higher level of scrutiny of the claims? I don't know. It just, when I read it, it raised a whole bunch of issues really hadn't thought about. Like, how do you verify, when these people really do want high SAT scores, high, tall, athletic, no glasses, whatever it is there some verification process? Because obviously they've got quite specific requirements. And
Now, are those facilities or services? Could you go to like the Better Business Bureau?
probably, I'm sure they are. I'm sure.
Any complaints to the organization?
It sounds like a 93A issue to me.
Right?
Yeah, he wants to triple
That's
damages.
what I've been thinking about.
No, it does. But because it appears to me their best defense is, I think, based on what I'm reading in between lines, no, we don't verify any of it. It's what simply they say.
I wonder what the buyer, I guess, knew about that. Did the buyer think that they were?
No, wouldn't you? I would think they would have. I would think if you're passing it off as, Angus beef. No. Right? If you want to think of it as a product, that someone has verified that.
Right.
Especially the people selling it to me. No? So I don't. I'll get you the article, and you can think, because I don't. Yeah, right. 93A. God knows what else. There's something. The way they were saying is we didn't I think that was like, we didn't represent him in any way, in essence. We just passed on what he said. Well, geez, you ought to tell me that then. Because we lied, right? So I'll get to the article because it raises some interesting issues. But let's do our nuisance cases and get the heck out of
Oh, I found it.
it. Oh, you got it?
Better Business Bureau, Fairfax Cryobank. Yeah, you can read reviews on it. They have an A+ rating.
A+.
Yeah, so you can do your research.
Oh, yeah, I would think. It's such a major investment. I would think that people are really trying to track it down, because I would think, again, where people get so personally and emotionally invested deeply, that it ought to be something you do with your eyes wide open, because halfway into it, you got a mess on your hands. I had a couple of cases go bad with kids where there were issues with respect to who the parents were and what should happen, and it's just a mess. And when you're this far in the process, I don't know, but where the hell's my case? But how do you even prove damages? Let's assume that there's no mental health issues. Okay, so he's just not as smart as you thought, right? No, no,
Yeah, I know.
right? So, well, so it's all nature, not nurture, too? I mean, what the heck? It seems to me, so you've got someone moderately intelligent instead of super intelligent, and both groups of people have their own problems. So, how do you value the loss? I understand the medical aspects of it. I don't know how you value. He's just not as athletic as he should be, or whatever else their particular requirements were. So I don't know. So let's talk about Pate. So I'll get you the article and you can look at it. So Pate versus City of Martin. And we have a sewage lagoon. And obviously they smell. And as I told you, there's a sewage treatment plant near me that when I go up the street in June, you get hit with that smell and it's bad. And some people, obviously, I'm getting to keep driving. Some people live right there. So how do you deal with that? Is that a nuisance? I mean, is the smell of people's waste, does that interfere with your use and enjoyment of the property? Yes, right? Yes. And it could affect a wider area so that it could be public, but if you are relatively close to it, it could be private as well. The farmer near us got rid of his cows because they were milk cows and you had to work them constantly. But there would be times in the summer when you went up there, my God, the smell of the rotted milk, I guess it was the milk, the corn, the cow poop. You turn the corner sometimes and you could throw up. So farms, you did that case? Farms? Huh?
But wasn't there an ordinance that said that farms are exempt?
There was a statute that said if it's ordinary farming operations, and that they would not be a nuisance. It's sort of a farm protection statute, as you remember. But so tell me about this, because they're looking for an injunction. And at one point in time, that was what people were talking about in North Andover as well, because there were lagoons, and if you lived near there, it was virtually intolerable for some significant part of the summer. And what they were saying is, cap them. Cap them. If you put concrete caps on all of them, and then they might take a little longer for them to ferment or whatever they do, but no one will smell them. The problem was, capping them was somewhere between a $10 and $20 million expense. And the sewage treatment facility said, we're not going to spend $10 to $20 million to resolve this. It's not worth it to them. But it certainly would have reduced it significantly. Here, they want an injunction requiring the city to take all reasonable steps to terminate the odors. And since it can be corrected by the expenditure of time and labor, then that makes it temporary, right? Temporary is fixable, permanent is not. So this is a temporary nuisance, not permanent, because it can be reduced or eliminated through the expenditure of time and money.
Correct.
Okay, so that's, first of all, we know, so we have defined it as a temporary nuisance. If they want damages for the interference with their use and enjoyment, then they have to show, it says here, the value of the use and enjoyment lost with and without the nuisance. A lot of times when we seek injunctions because of nuisances and the like, it's we're trying to enjoin the future damage, the future harm. But we also have lost value going backwards. And so depending on the statute of limitations and the like, we can collect damages for the past injury, the past loss, and we can hopefully get an injunction to stop the future damages. But you got to introduce the measure of damages. It says here, the measure of damages for temporary nuisance is injury to the value of the use and enjoyment of the property. Here they said, one way to prove it is that the rental value of the property is diminished by the nuisance. So that would, that's a simple way of calculating my loss, is that, listen, 2-bedroom apartment goes for $500 without the smells. Anything near it, $350. My loss is just the difference between $5 and $350, so it's $1.50 a month for whatever period falls within the statute of limitations. Relatively straightforward if that's the route you go. But you've got to show what the value of that loss is if you want to be able to take damages for the injury. But they have to show the impairment of the use and enjoyment of the property. Now, it says the odor from the scum is so strong that it makes habitation of dwellings in the vicinity almost impossible. The evidence shows that the condition can be remedied by the adding of enzymes to the sewerage and scattering or churning the surface scum so that it will settle to the bottom of the lagoon.
Yeah, now this is the most important thing for this case. Stay in law school, so you don't have to be that guy who drives the motorboat to the pool, you know what I mean?
I was going to say, next time you think whatever you have to do is will be a shitty job.
Yeah.
You remember this job, and you say, "Thank God I don't have to do that," because they found a relatively easy way to alleviate some of the problem, which is to have someone drive around in the lagoon that's full of poop. And churn the surface scum, which stinks, it says, with the motorboat. And that will make it right for everyone else. And, it's a job. And so no matter, I do think you ought to think about that no matter how bad your next job is, because this is a pretty bad job. And then it says the odors would be magnified by seasonal heat and lack of wind and rain. So it's even worse when you're out.
And he quit. He obviously quit because they stopped doing it in the summer, right? I think the guy just said, I'm done. I'm out of here.
Imagine how bad it must get. Imagine how bad it gets then as it gets hotter and hotter and you're in that damn boat. Even if you're on the ocean in a boat, it's hot. Now imagine you're in this place. So at any rate, it says here, a nuisance has been defined as anything which annoys or disturbs the free use of one's property or which renders its ordinary use of physical occupation uncomfortable. Obviously, this goes beyond that. It gives offense to the senses, as it says. I don't know about violates the laws of decency, but it does obstruct the reasonable use of that property. Even with the remedial step, if the remedial step stays in place, then maybe the nuisance will be alleviated. And since it can be alleviated, it's temporary. And I also think this case is a good example of equitable remedies. The court is supposed to, at times, be creative, right? There isn't an entitlement to anything when we think about equity. And I think the whole idea that we could resolve this relatively cheaply and easily with the motorboat is interesting, that the court looks at that and says, well, and especially if I apply it to my own town, when you think about $20 million or pay someone a relatively modest amount to try and do this job, and there will be people, you may not, but there will be people that will be happy to have that job to do. So the motorboat during the summer season, especially as it says, since it's most needed, then either they can think about how to alleviate this to a greater extent and make the neighbors happy, pay the damages, or the court should in fact enjoin the nuisance, or at least if they're not going to enjoin the nuisance, mandatorily order them to take steps like they have in the past to reduce it. And that's the beauty of equity, is that the court can fashion relief as they see is appropriate and fit to the circumstances. There is a depreciation in the value, in the market value of the property, and the measure of damages for a temporary nuisance, as it says, is the injury to the value of the use and enjoyment of the property. And usually that's shown by the loss of rental value. I don't know whether you can try and quantify being able to sit out on your porch or your deck and have a cookout and things like that. But those are the questions we talked to you about when we were doing the pig farm case and the like. So you ought to think about that, because you see a fair amount of concern over nuisances. And again, to me, it's because this is where people live, this is their home, and it affects them 24/7. And so over the course of representing people, I've had a fair number of them. And they're not always exactly as you think they're supposed to be, because different things affect people differently. One more to do. Myers versus Arnold. And I like this case too. So she wants some fill. And there's a road job up the way. And she's got 20-acre tract of land. With her home on it, and there were other land that she had intended to construct a residence on the eastern portion of the property. So she was looking for fill. She talked to the supervisor of the road job, saying she needed a couple loads of concrete. And she preferred that it not include rubble or dirt. She was particular about the fill she wanted, at least that's her testimony. Instead of getting a couple loads, they decided to use most of this road job and stick it here because it was cheaper for them to do. It had concrete in it, but it also had the steel reinforcing rods, and it's 8 feet high in some places and covered approximately 7,500 square feet.
70 loads, right?
Right? 70 loads of concrete, steel rods, anything else that they found in the road that they chose to get rid of. She contacted him and he said, no, go to hell. You asked for it, you got it, keep it. And she sues. And so is this, is this a trespass? Is this a nuisance? What is this from a legal standpoint? Because I know we go into damages. Well, what would you say the violation is?
I mean, it would have to be a breach of contract, because
Do you think it's breach of contract?
the problem is it's with her consideration, so that might not be it. There's nothing bargained for on her side, unless you're going to say that it makes it cheaper for you not to dump it. See, I'm just worried about whether there's consideration for a contract.
What do you guys think? What's the legal injury here?
Loss of use of
I think it's a nuisance.
enjoyment of the land.
So it's a nuisance?
I think so.
How about a trespass?
Well, how about a trespass? That's what I'm asking you.
Well, they had consent, if you buy the plaintiff's story, they had consent to dump a couple of loads, but they did not have consent to dump 60 to 80 or whatever
And
it
then
was.
she refused to take it off the property.
So what is it?
Trespass, then, yes.
Trespass. So what's a trespass again?
The intentional.
The entry onto someone else's land without their permission?
Right.
Yes.
They had permission for a couple of loads, but
but they don't have permission for 80 or 70. At some point, they've gone, and by the way, that'd still be a trespass, right? If I have permission to come on someone's land for one thing, but decide to do others, then I've exceeded my permission, and it's still a trespass. And nuisance is an unreasonable interference with one's use and enjoyment of the land. Or you think it could be a breach of contract if we could figure out whether they ever had any agreement at all. Well, you think about it. I'm not sure. It's an interesting question, and the case doesn't even deal with what the legal argument is, because it's either you accept that she asked for 80 truckloads or not, and the plaintiffs, depending on that, the plaintiffs either win or lose. But you should think about it's obviously an interference with real property situation, but what the remedy would be. The total expense to remove the concrete by the John Lord, who's in the refuse removal and demolition business, he said it's going to be about $18,200. If he could find someone who wanted it to help with erosion control and the like, then he wouldn't have to pay to dump it, which, think about, I don't know how, I'm just looking for the date quick. Dumping fees are ridiculous now, so God knows what this cost would be these days to find, if you had to pay someone to accept all of it. And there was testimony. Tell me why that's relevant. It says, prior to resting their case, plaintiffs called Howard Arnold, president of the defendant company, pursuant to Section 60. That doesn't matter important. He testified that the contract price for the Leroy construction project was approximately $2.4 million. Why would the value of the construction project itself be relevant to the plaintiff's item of damage for the cost of removal? I mean, that seems like we're just trying to stick a big number in there so that either whoever is going to be determining the cost of removal says, well, 20 grand isn't that bad. I mean, because why?
Isn't it relevant because it would only have been $500 more to that price to move it elsewhere?
Oh, so you're saying it's
I think they're going to show
that it wouldn't have cost them any more.
Right.
On a minuscule basis.
Right, and I think they said that.
Yeah, it's $490. They said
$490.
They said $490 by putting it there instead of dragging it down to the cemetery.
Wouldn't have been as,
And I need to know that the total contract is 2.4. I need to know that. I mean, that's really relevant to a fact of consequence of the litigation. I know.
Probably not, but it's kind of.
Well, it does make us more sympathetic to the plaintiff. On a job this big, the difference only being $490. What the hell? Why did you dump it there? You should have moved it. But I don't know whether we're using it for an appropriate purpose.
Could it also show, I mean, this is the defendant offering this testimony, so does it also?
No, this was plaintiffs.
Oh,
Plaintiffs offered the testimony, top of 319, that the value of the contract was $2.4 million.
oh, okay. I was going to say, this could be helpful to the defendant to show that they did not really have a financial incentive.
Yeah, there was no, but they,
$2.4 million, $500 to dump some concrete is a drop in the bucket.
well, but I think that's why the plaintiffs are offering, and I'm just wondering whether we needed to know that it was a $2.4 million job. But obviously, it helps get them what they needed to be, get, or at least as they see it. But I'm just asking you guys to think if you were trying that case. I would have objected to it. I don't see where that's necessary, and I do think it's potentially a 403 issue with respect to this, because we're all sitting here saying it's a $2.4 million job. The difference is $500. She didn't want it. Why did you put it there and remove it? And it makes it much easier to win. To find for the plaintiff, I think. With our sympathies, I'm not so sure it's relevant evidence. At any rate, and the 490 figure is a little bit below that. But what's her measure of damages? First of all, is this a temporary or permanent damage to her land? What's the difference between temporary and permanent?
Fix it, it's temporary.
Okay, is it fixable?
Yeah, you can call it.
Yeah, right. It's not gonna be easy necessarily to lug all this crap out, but it is fixable. There is an ability to repair it, and so it is the value of the damages simply the cost to repair, or should it be what the value of an acre of land is? Because that's in essence what they've consumed by this, and the acre of land is somewhere between $650 and $750, looking at the information on the top of 320. And obviously, if you're the defendant, I'd rather pay the $650 to $750 than the 20 grand that you're looking for to remove it. If I'm the plaintiff, I'd prefer the 20 grand. And in order to get us there, if I have to say I'll build my house right on that very spot where all that concrete was put, then I can do that. But I wonder whether that's really going to happen once I've got my 20 grand. But it's a question of whether we're looking at the cost to repair and whether it's for home use or commercial value. If they were selling an acre, if they were in the market of selling off an acre of land at the time, then their loss might well be limited to the $750 to $650. It says here on 319, it says, at the close of the first day of trial, defendant moved for a directed verdict, arguing that the plaintiffs had failed to present sufficient evidence on the issue of damages. What's a directed verdict?
Rule 50.
Yes.
Judgment as a matter of law.
Judgment as a matter of law in the federal system. What's the standard?
Reviewing the light most favorable to the non-moving party.
Keep going.
Shit.
I don't see it.
To prove that no reasonable jury could find them based on the evidence they have presented in court that day.
Good, right? It is Rule 50. In Mass, we still call it a directed verdict if it's done prior to closing arguments, and judgment notwithstanding the verdict post-closing arguments. Federal law, federal rules now, and both of them are Rule 50. 50 in state, 50 in federal. Federal court now calls it a judgment as a matter of law. And as Natalie correctly points it out, is in viewing the evidence most favorable to the non-moving party, whether a reasonable jury could find for the other side on the basis of the evidence presented. It tests the evidence introduced at trial to determine whether it's sufficient for the jury to be able to make those determinations. So they moved for a Rule 50 motion because there was some issue with respect to how they were not only attempting to measure damages, but whether there was sufficient evidence that they could measure damages on the basis of what they submitted. The court gives the jury the instruction at the end of the day by telling them, since it's temporary, you can look at the reasonable expense of removing the concrete. The defendant wanted the instruction given to them. It's the lesser of the reasonable expense of the necessary repairs, or the difference between the fair market value immediately before or after. If we go with the fair market value approach, they've lost a lot of money. They've lost, what are they looking for, 18.5? They've lost 17 plus 5 plus. What is appropriate under the circumstances when you've got property that can be repaired? Is it only the diminution market value, or is it at the end of the day the cost to repair, to put the property back in the position it would be but for this injury?
I think it was because it was personal use, it was the cost of repair.
Yep. $12,000 is what the jury verdict came in for, which representing the cost to repair as the jury found it. They're not in the business of selling acres of land. If they had, then the value might well have been different with respect to what the items of damage are. They want their property restored to its, at least they say, they want their property restored to its prior condition. And because they do, and because they have put in evidence of the damage and the cost to repair that damage, under those circumstances, they are entitled to have the property put back into that position, not just simply the diminution in value. And again, if you look at page 321, this is where we start to think about it. Is the first thing you start to think about in calculating damages is whether the injury is permanent or non-permanent. If it's permanent, the measure of damages is the market value of the realty before the injury less its market value after. Where it's non-permanent, then the measure of damages is the cost to repair. And it's a pretty straightforward approach, but it starts with you then having to ask.
Would that be further quantified with business or personal though too, right?
Yeah.
Like a second.
Yeah, well, because if they just simply sell acres of land, then then it'd be economic waste to simply require the property to be restored. What's one $750 acre is just as valuable as any other $750 acre. So you're going to get, if you're in the business, you're going to get the loss to your business. Here it's because it's personal use as well. And as it says at the end of the case, the jury chose, however, because there is conflicting evidence in the case as to what really that agreement was, and there are only two people who can tell us what it is. Jury chose to believe the plaintiff's version of it, which, I mean, to me it's a little more logical, but all we're looking at is paper. I'm not sure anyone would want 60 to 80 loads of concrete and steel rods and everything else to look at that. I mean, I can't imagine what that, it really must have looked like something. It certainly wouldn't necessarily be where you'd want to live if all you were looking for is some fill. Defendant lost. Jury found for the plaintiff. The value is the cost to restore, and that's what we're looking at as the proper value because it's a temporary nuisance, not a permanent nuisance. Questions?
You know, this case is real similar to one in contracts where this couple had let some strip mining be done for coal, and the deal was at the end, you come in and fill up the hole completely, and of course they didn't do it, they sued and all that, and the court did not award the 20 grand that it would take to fill in the hole because it would be economic spoilage, right?
Waste,
and they didn't allow it. And I was trying to think, why is that case different than this one? It might be because that was commercial.
Oh, I was going to say that has to be the difference because this is not a standalone case. This is the general rule, is as you're looking at the difference between temporary and permanent,
right.
and that sounds temporary. You could fill it back in, and they should have, you know. So what, they just give them the diminution in the market value and all?
I mean, it's one of I hate that case because I mean it was pitiful what they got. So I mean they had made a fair contract that hey, when you get done, you fill it in. And they got like a few $100s for the diminution value, and I always thought, man, this just doesn't seem right. But it was the economic spoilage was the reason. We're not gonna pay $20,000 to fix a $300 hole. That's
well, here they're paying $20,000 or $12,000.
Yeah, but now you see flip, right?
Yep, because of personal use. Good. See you guys next time.